Well, thanks for everyone for coming. My goodness, there's people. Yeah, do a good job. Don't listen to the paper, Adam. Just it's all on tape. Watch the tape later. So it's especially wonderful to have Andy Koppelman here at the conference. So 33 years ago this spring, I was taking his class. I had just switched for the previous fall from being a physics major into being a politics major. I'd written a paper on Germaine Grisey and John Finnis in the fall with Andy. In the spring, he had a class, Discrimination in the Law. So he had the Anti-Discrimination Project. And so he was going on and on about this stuff the Supreme Court said about the equal protection of the laws. And I just thought, that's not what those words mean. So I had these two things. One is like, it's about protection, right? And I started kind of researching that, found John Harrison's paper from about a year before that. But I also thought I really should figure out what I think about discrimination and how the 14th Amendment does work. So earlier in my, I figured out which clause we should be using for anti-discrimination law long before I figured out what anti-discrimination law should look like. So this is another page. I guess I have, so I'm not sure how many, I have a bunch of small projects, Citizenship and Solicitude in the Harvard FedSoc Journal is the kind of the first bigger one. So that's explaining why, and again, this is something that Andy was hassling me about 33 years ago. Washington v. Davis, how can you have this complete lack of concern with disparate impact constitutionally? So I had a paper on how we should overrule Employment Division versus Smith and Washington versus Davis. So if you're wondering what should we replace Employment Division versus Smith with, it's not Sherbert and Yoder, but a rule that if you're a citizen, you get equal solicitude for your interests. So impacts on disparate racial groups, impacts on disparate religious groups, disparate impacts on different racial groups or religious groups, raise the need for a question to be asked and answered, well, what's the deal with that? Just like running I-40 through the Memphis Zoo, or cutting off, not through the Memphis Zoo, but cutting off the Memphis Zoo from the rest of Overton Park needs an explanation. So this is the sequel to that. Same thing, same view, but with gender discrimination, rather than this nonsense the Supreme Court's been peddling since 1976. So apologies, the first part on, kind of explaining why the tiers of scrutiny are terrible. I really don't engage with a lot of really good literature by people in the room or people who have been in the room recently, people who have presented papers at the Originalism conference in the last few years. So there's a lot of work just doctrinally about what's going on with the Supreme Court that I don't spend a whole lot of time with. But Craig has this, previous cases established. No, they don't. It's making it up in 1976. So that's a problem. It says classifications by gender must serve important objectives, substantially related to the achievement of those objectives. What are these terms? Important, substantial. What do they mean exactly? That's unclear. The whole notion of having separate buckets for race, gender, and age historically doesn't fit 1866 stuff, which said women and children are citizens. They don't get political rights. So the Republicans said this over and over. The Democrats said, 14th Amendment, you're going to give voting rights to the freedmen. The Republicans say over and over, no, it won't, because women and children, they are citizens and they get civil rights, but civil rights are not political rights. So the discussions in 1866 lump all these three things together that are placed in these three separate buckets. We don't know what the terms mean. So there's 7, what do the tiers of scrutiny do? They replace one difficult question. Is this particular distinction arbitrary? That's basically the way anti-discrimination law works before 1938 or so. Replace the one with 7 imponderable question. First, what kind of level of scrutiny do we get? And then what's narrowly tailored, what's compelling, what's substantial, what's important, what's rational, what's legitimate. So it's replacing one difficult question with 7. Is tradition a plus or a minus in that question? Supreme Court fussing about that in Scrutiny and the Little and BBJ arguments. They may clarify it, might not. Okay, so you got these 3 buckets. They're all treated the same in 1866, but everything in the bucket is different. So the stuff in the different buckets is treated the same in 1866. But if you're going to have with 3 buckets, the stuff in these buckets is too heterogeneous. So the equal treatment doctrinally of all gender classifications. So only 3-2 beer only for young men, and draft registration only for young men. Those just seem like, or only for young women, and draft registration only for young men. The notion that those stand equally in need of justification seems absurd. And then, you get this difference between rational basis and intermediate scrutiny. In the Scrutiny briefs, the Solicitor General trades on this, like, well, if you don't have intermediate scrutiny, all you've got is rational basis. You don't need to have that kind of gulf. That's a completely artificial gulf created by the doctrinal framework. We need something more nuanced. So what should it be? It should be citizenship. The distinction between political rights and civil rights is the basic framework. That's one group of people in control, another group of people who are the beneficiaries of this arrangement. That's a trustee arrangement. So what do you do when you have a trustee with multiple beneficiaries? Lots and lots of cases say you have this rule, you have to have fair and impartial attention to the interests of all parties concerned, which means you're going to have to pay attention to impacts, akin to, I think, paying attention to the impact of I-40 driving right next to the Memphis Zoo. Women deserve solicitude for their interests because they're citizens under the 14th Amendment. So the notion that women were not citizens under the 14th, I hear this sentence every so often, like, well, those 19th century people, they were so mean to women, they must not have treated them as citizens. Well, they were kind of mean to women in certain ways, but they certainly treated them as citizens. So Minor versus Happersett goes at great length. I mean, it's quite tedious, arguing that women are in fact citizens. Of course they're citizens, but they don't get voting rights. So all the early arguments for women's voting rights under the 14th Amendment, they are rebutted not by saying women aren't citizens or they don't get equal civil rights. They are rebutted with the political-civil distinction. And that, I think, is itself a really telling fact that women do have 14th Amendment rights. What are the rights? Yeah, right to equal solicitude. It's going to be teleological. It's going to have a lot of controversy. It's going to depend a lot on empirics, okay? But it's going to be real scrutiny of what's going on. I think Carpenter's argument in Bradwell versus State is the kind of argument that we should credit. Salmon P. Chase, dissenting, albeit too sick to write out his dissenting opinion before he dies. He I think, had it right. So that's what we should go to instead of this tiers of scrutiny gobbledygook. And how does that mean we should handle Scrutiny? You can make an argument based on equal citizenship, based on equal solicitude for all citizens' interests, for the opposite result in Scrutiny. But this is the language, I think, that we should be using. It poses an empirical question. Is the state actually looking out for the interests of people when they ban biological men in women's athletics, when they ban cross-gender hormones for kids? Seems to me that, that they probably are, but it's an empirical question. A lot of the questions are going to become empirical, fact-laden, which we might like to be definitional, but that's just sort of how it is. Thanks.
It is a pleasure to be here, but also a special pleasure to comment on my friend Chris's paper. I love seeing him at these events. I love arguing with him. We have a great time. So we're going to continue our argument right here. This paper is about how to think about a constitutional sex equality doctrine. And Chris's goal is to bring back ideas of equal citizenship from Reconstruction. I just want to point out, there's nothing in this paper about the problem of non-citizens. And there are plenty of people in the country who are non-citizens, and so he has nothing to say about that. That, I think, is an interesting question on its own. I think that really requires due process and equal protection, even though we have an argument about where equality law resides. I also agree with, I want to start with agreeing with Chris that the tiers of scrutiny system we have now doesn't make any sense. The intermediate scrutiny in particular is very vague and ill-defined. The reason for that is that intermediate scrutiny is a compromise between the justices in the middle of the court in the 1970s. So you can thank, Potter Stewart and Whizzer White and especially Lewis Powell for it. And the reason why is they just didn't know what to make of women. They just couldn't figure out how women's equality worked, especially with respect to questions like pregnancy. And what they regarded as natural or biological differences, which were actually social differentiations which were layered on top of biological differences. And so they just punted, and they created this doctrine called intermediate scrutiny, which we live with to this very day. I want to start with a very interesting point that Chris makes as almost as an aside in the paper, but it's a good way of thinking about the equality problem. What he says is it's really puzzling about the fact that sometimes constitutional cases deal with tradition as a good thing, and sometimes constitutional cases deal with tradition as a bad thing. What's up with that? Let me try to give an account of what is up with that. So unlike the doctrines of liberty, equality doctrines are not based on tradition. Equality is usually in conflict with tradition. And that's because many equality questions, although certainly not all, are about dismantling existing social or status hierarchies. A traditional society is generally organized in hierarchies of power and status with an ideology that supports it, that people believe in, often in good faith. So equality is what you use to challenge an existing system of social hierarchy and also the ideology or belief system that justifies the hierarchy. So because hierarchies already tend to exist in settled practices and therefore are usually traditional, you can't really use tradition as a means of gaining equality to justify a change in norms, except if you describe equality at an extremely high and abstract level. So when you try to ground equality doctrine in tradition, basically what you get is entrenching inequality. So that's why, in fact, tradition is a bad thing in equality doctrine, whereas it might be a good thing in other parts of constitutional doctrine. Chris says, and I'm going to quote him, rather than intermediate scrutiny, the court should ground women's 14th Amendment rights in the 19th Amendment tradition of equal citizenship. And he spends much of the...
century. Go ahead.
Yeah, 19th century tradition, of equal citizenship. He spends a lot of his time arguing that women were considered equal citizens during the Reconstruction, and Chris is completely right about this. The unmarried woman, the femme sole, was the model of someone who enjoyed civil equality but not political equality. But the real question is what follows from this formula, and in particular, what did equality mean for women in practice during Reconstruction? So there's an important word that's missing from Chris's article. That word is coverture. At common law, married women lost all of their common law rights upon marriage. They were civilly equal in theory, but not in practice. And everyone understood this. In the debates over the 14th Amendment, the supporters of the amendment said this was perfectly consistent with the new amendment, which did not seek to alter the common law. Indeed, civil equality was based upon the protection of common law rights, common law conceptions of liberty, of which coverture was a part. And Bradley's argument in Bradwell basically is based on coverture logic. He says, since Myra Bradwell can't make contracts, she's a married woman, how can she possibly represent clients? Coverture is going to raise a difficulty for our attempt to try to make sex equality based on Reconstruction era ideas and civil equality. Chris says at one point that he thinks that the concurrence in Bradwell by Justice Bradley is based on an empirical mistake, a mistake of fact. But I think it's not simply a mistake of fact. It reflects the fact that the framers had wrong ideas of fact. They had different values than we do. Their values were embedded in a social hierarchy of gender that they thought was natural and normal, and they held these views in good faith. Our contemporary values about sex equality are not because we discovered scientific facts that they didn't know. They're based upon a century or more of political agitation by women who asked for men's foot to be taken off their necks. The Reconstruction framers were perfectly happy to keep their feet firmly applied to women's necks because they did not view male control over women as at all problematic. To them, it was, to use Chris's phrase, equal solicitude. It was equal concern for the differences between men and women, which they regarded as based in biology and the nature of things. So both Chris and I believe that we are not bound by the original expected application of the text of the Constitution. But the constitutionality of common law coverture is not only the original expected application of the 14th Amendment. It is part of the original legal meaning of the 14th Amendment, and it is part of the original law that surrounded the 14th Amendment. Chris's argument is about the original legal meaning of civil equality and the original legal principles of civil equality. These are common law ideas. Coverture doctrine was part of that meaning and part of those principles. It was not simply a mistake of fact. Ironically, Chris cites the Seneca Falls Declaration with approval to show that women were understood as equal citizens by the Reconstruction framers. But the men, and I use that term advisedly, who adopted the 14th Amendment were opposed to the ideas contained in the Seneca Falls Declaration if it meant that women, and especially married women, would have equal economic opportunities with men. And they most assuredly did not want women to have equal sexual freedom with men. Their views about women's equality were largely paternalistic, and the ideas of Seneca Falls are decidedly anti-paternalistic. Coverture meant that women were theoretically equal citizens with men, but practically not equal, because in practice they would have no common law rights for most of their lives, and all women were expected to leave their father's house and go into their husband's house. Spinsters and widows had common law rights because there was no longer a man to rule over them. Chris uses the logic of virtual representation to show why women had civil rights but lacked political rights. But the logic of virtual representation is the same logic that justified coverture. Both logics are paternalist through and through. The idea is that husbands would look out for their wives' interests so they did not need common law rights. They would look out for women's interests in governance so they did not need political rights either. And if women were to enjoy such rights, it would disturb the harmony of the family. Chris rejects Steve Calabresi's argument that the 19th Amendment should affect our interpretation of the 14th Amendment. But the point is that the 19th Amendment rejected the paternalist logic of virtual representation. You could no longer assume that men adequately represented women's interests in governance. The 19th Amendment is anti-paternalist in this respect. If we reject this logic in political self-governance, we must also reject the logic in economic self-governance as well. Self-determination in politics implies self-determination in other areas of life and points toward an end to men's paternalistic rule over women. If you want a cite for this, just look at the 1923 opinion by Sutherland in Adkins versus Children's Hospital. Chris wants to replace the current formula with the principle of equal solicitude. Solicitude means concern. So his formula is a little bit like Ronald Dworkin's formula of equal concern and respect. But the formula that he has in this article leaves out the word respect, which I don't think he meant to do. But for Dworkin, respect here means equal autonomy and liberty. So it is an anti-paternalistic idea. By contrast, in this article at least, Chris has no problem with paternalism. It is baked into his theory of equal solicitude. For him, the central question is whether, I quote, a law represents good faith, paternalistic concern for all citizens' interests, or rather reflects callousness to those interests. Again, quoting, only if the lack of such a good faith belief is clear and convincing, if it is apparent that its real object is not to protect the community or to promote the general well-being, may judges intervene. Now, presumably, this formula applies not only to laws affecting trans people, but also gay people and women. And I wonder whether it applies to black people as well. I mean, we have to talk about colorblindness in the context of this story. As an example, Chris cites with approval an 1869 California case about keeping women out of saloons after midnight. I am not sure what we are supposed to make of this example. It seems to give paternalism a bad name. I think that the test of good faith solicitude is inadequate, and certainly a test that we must assume good faith unless there is clear and convincing evidence to the contrary. The reasons are tied to what I said earlier before about how inequality works. Sex discrimination is not based on animus in general, but rather on the belief that the state can treat women differently in terms of opportunities, markets, healthcare, and sexual autonomy because of natural differences rooted in biology. This is an ideology, a worldview that justifies unequal practices. If people hold to that worldview in good faith, they are offering equal solicitude, that is, concern under Chris's test. The problem is that stereotypical thinking and moral panics about women, gays, and trans people are perfectly consistent with people having good faith beliefs and fears. So our test of equal treatment today cannot simply be based on good faith. It has to be a test of public reasonableness. And I think actually Chris probably agrees with me about this. It just doesn't appear in this article. You have to be able to challenge good faith belief by showing that whether or not people honestly believe they are treating others fairly, they are not actually doing so. You want to make sure that a law isn't based on stereotypes, fear, or prejudice, or a political desire to scapegoat people. These are the central concerns of the 14th Amendment's ban on class legislation and caste legislation, which lie at the heart of the 14th Amendment's guarantee of equal citizenship and equality under the law for all persons, not just citizens. So I come back to where I agree with Chris. We both agree that the 14th Amendment has a conception of equal citizenship and equality under the law. And I think we both agree that this conception involves a ban on class legislation and caste legislation, which is legislation that lacks an adequate public purpose. But what I think we differ on is whether or not a theory of equal solicitude by itself will be able to get us where we need to go.
Okay, so I think Jack wildly overstates the unanimity during Reconstruction. So Carpenter is arguing for Myra Bradwell, and he is freaking Matthew Carpenter, okay? So salmon freaking peach. I mean, it is not unanimous. In 1872, the Republican Party has a plank acknowledging women's rights to civil rights. 1876, they amp it up. Adkins, 1923. So it's like, okay, so Eric Siegel used to say this all the time. He used to say, male chauvinist attitudes toward women are part of the meaning of the 14th Amendment. And I was like, Eric, you can look at this up. I've got at least 40 tweets where I say like, almost the exact thing. I say the meaning is expressed by the text of the words of the Constitution. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. There's no way to understand those words to be communicating a rule of coverture. Okay, so is coverture unconstitutional? Not per se. It would depend on the empirical question about whether these are male chauvinist assumptions about men looking out for women's interests. Mississippi gets rid of coverture in 1839. Does Mississippi have better attitudes toward women immediately? When they change the coverture rules. It's in flux right during Reconstruction. It's an empirical question, just like the natural timidity and delicacy, which Bradley appeals to in Bradwell, is an empirical question. And there were people in 1866 who were disagreeing with those empirical assumptions. like Carpenter, like Chase a few years later, like the Seneca Falls ladies a few years before. Okay, so it's an empirical question, and it's fact dependent. It's not baked into the original meaning. So anyway, that's a little bit grumpiness. Yeah, the meaning is expressed in the freaking text. I mean, come on, people. Come on, you can't. The text of the 14th Amendment does not express anything about coverture. It expresses a general principle which, in tandem with other premises, can give you conclusions about coverture. But it's in those auxiliary premises. It's not the meaning, not the original meaning.
This is vintage Chris, and I love it. My question is, I think, heavily redundant on some of Jack's comments, but rather than pass, I want to ask it again just to give you another chance to respond to it. So I'm struck by the conclusion that, quote, only if a statute is clearly not based on a good faith belief that it will serve women's interests as well as it serves the interests of men, may courts properly intervene. That seems to stand on its head the current admittedly non-originalist jurisprudence, which is designed in large part to smoke out romantic paternalism. Your view seems to allow it, so long as men believe in good faith that VMI is no place for women who will suffer there, or for that matter, that women will benefit from fulfilling their God-given role as wife and mother rather than practicing law, the court should step aside. So again, as Jack says, you dismiss the Bradwell dissent on the ground that it was factually inaccurate, but was that rule against women practicing law, quote, clearly not based on a good faith belief that it will serve women's interests as well as it serves the interests of men? You and I might find that belief wrong, though there are huge segments of our population even today who would disagree. The trad wife movement is thriving right now. But in any event, I feel comfortable saying that those who hold those beliefs generally do hold them in good faith, or at least it's not clear that they don't hold them in good faith. Again, I can't say that a rule like that is clearly not based on a good faith belief that it will serve women's interests as well as it serves the interests of men. So, I mean, I think the question of the constitutional status of sex discrimination is a difficult question for originalists, at least as a matter of public relations. And I commend you, I suppose, for having the courage of your methodological convictions, but I wonder how you're going to sell Amy Barrett on this one.
Thanks. I also have a question about the relationship between good faith and facts. So the real state of the nature of women as opposed to our views about women's roles. And along those lines, I'm just curious about what the 19th century mindset would have been about that question. So in the context of freedom of speech, there's a right to speak in good faith on matters of public concern. And Robert Post has an article about this, talking about how moralistic they were in their assessments of what counts as good faith. That good faith did not just entail a subjective mental state of maliciousness, but it was actually seen as a failure of one to properly account for things that one should properly account for. As a person charged with certain authority, in that case, the authority to speak in public on a matter of public concern. So I wonder if you were to take that view into the legislative context, whether there wouldn't then be a way of responding to Jack, but then it does make the assessment more complicated because now we're not just asking a subjective mental state question, now we actually are getting more substantive in our assessment of the nature of things. Thanks.
Yeah. Thanks, Chris. Thanks, Jack. Marvelous exchange. So my question is about Part 6C, 35 to 36, Ex parte Smith and paternalism. And so you make the claim that in Ex parte Smith, the court is saying that paternalist legislation, right, is sort of built into the social contract. But I don't think that that's what Ex parte Smith is saying. So obviously, and I know you don't misrepresent the court here, the word paternalism does not appear anywhere in Ex parte Smith. And if you read past the passage that you cite, you get the court sort of does this long exposition of social contract theory, right? And then it talks about how that applies to this ordinance that prevents women from being in drinking establishment after certain hours, right? And it said, and the court says that it's got some stuff about we assume that the enacting body found the necessary facts, but what facts are necessary, right? So the facts that would be necessary is that the presence of females in the places and at the time mentioned in the ordinance is of a vicious tendency and hurtful to that sound public morality, which by common consent, that is everyone thinks, is indispensable to the general well-being of society. So that's not paternalism, right? That's not that we're doing this for women, for women's own good. They might have thought that, but this case does not establish that. What this case establishes is that public morality, which is necessary sort of to the fabric of society, is a legitimate end of legislation. So I think you need to take out Ex parte Smith. It just does not establish the point that you're using it for.
So one thing about Bradwell, okay. Bradley says, look, women can't own property, therefore they can't be lawyers. Anybody can be an agent. A 5-year-old child can be an agent. You send your kid down to the butcher to buy a ham or something. Scrooge, to take this money, like Scrooge will be bound by the acts of his kid in the kid in the street acting as an agent when he goes by the Christmas turkey. The fact that women can't own property in their own name if they're married says nothing relevant about whether they can act as an agent, as a lawyer for somebody else. Okay, that kind of fact, just the problems with Bradley's legal analysis, suggests that he's not really promoting women's interest. And the fact that arguments like that get made poorly, I think, suggests. So I would be, moosier about I guess I would look at, stuff like Williamson v. Lee Optical. Is this based on a good faith belief that, these poor people, they're going to get, bad eyeglass prescription? No. This is rent seeking. Okay, what is this? This is men trying to. What's going on in banning women from practicing law? Men preventing competition, lower production, higher prices. It's good for current sellers. Adkins. So I just think you have a duty to inform yourself of the economics, and I think you can show that the economics is this doesn't actually serve the common interest. Yeah, Judd, I think that's that's right. That it's got to be moosier. I'll take a closer look. A lot of y'all read these cases as non-paternalistic in ways that so you're basically they don't want prostitution, and I guess I just think prostitution is bad for women. But I guess people who don't think that they're just not reading this as paternalistically looking out for the interests of so. Preventing women from going out late at night into bars strikes me as, the kind of thing that you might tell your daughters not to do, for their own good. Okay, but telling people not to drink, I think that's just kind of classic paternalistic type stuff, and a lot of you read these cases differently. So I will look at the details certainly, but. Oh yeah, immigrants, non-citizens. Yeah, our Constitution's not perfect.
Okay.
I really liked a lot of this paper. I think it's missing some things. So the first portion, I think I'm still not quite sure what your position is on coverture, but I think you have to make clear if your position is that large portions of the legal landscape at the time of the 14th Amendment were unconstitutional. You need to say that if you think that, or if you're not sure about that because, it depends on facts and good faith or whatever, I think you need to say that. Those are just key issues. Those are key originalist issues, and I don't think the paper says anything about that really now directly. So that's sort of point one. I also think, so that goes to the original meaning question. I think it also would be very helpful to go through the cases like Craig and VMI and actually discuss them in illustrating what your position is. So you say, well, this is going to depend on the facts, and if that's your position, I would specify, I would do some of that because it's not really, expressed. That's going to make the paper longer. I think if you were looking for something to cut, I think especially the early discussion of stare decisis with respect to Craig v. Boren and the like, I sort of felt it was like putting the cart before the horse. I want to be convinced on the original meaning first. So I would go there and I would specify a lot of your position. Then when you've convinced people, we can worry about,
So I am broadly sympathetic to the idea that the tiers of scrutiny are made up and that there's a certain logic to the 19th century framework, but I think the way you're putting this out is missing an extremely key idea for what is necessary for what you're proposing to not lead to wildly many sexist laws. I think you're right that the ultimate reasonableness or arbitrariness of all sorts of laws turns on a bunch of factual questions about what women are like, what black people are like, what Catholics are like, what people from the wrong side of town are like. But to have a prayer of not feeding into the prejudices that exist, you have to include as part of your tool for deciding whether something is reasonable or arbitrary, or as sort of part of the rule of decision, the idea that we should be extremely skeptical of regulations involving people that there is a long history of believing that there is prejudice about, right? So what's not in the paper, which I think needs to be there for this to have a good fit between actually good outcomes and what I think you're going for, is building that in, because you're going to get a huge number of wrong answers in terms of unreasonable arbitrary rules following this the way you've written it, if you don't include oh wait, this is an area we have historically f***ed up a lot, so we should be very, very careful.
I really like the paper. I feel kind of a conflict of interest here because I know you well, Chris, and I'm afraid that if we all are in agreement in telling you that you're wrong about something, this is going to make it less likely you'll change the paper. So maybe I should just say, you go, girl. No, but I'm afraid I'm going to join the chorus a little bit on 2 points. But first of all, fun fact. It turns out a woman had been admitted to practice law in Illinois prior to the decision in Bradwell. And why this did not moot the case, don't know. No, it's not known. Maybe they didn't know about it. Maybe they didn't care. I don't know. But and secondly, I think the same historian who noted that Justice Bradley's opinion was treated in Washington circles with some amusement. In other words, it was not thought to be a serious thing. It was actually the subject of some ridicule. Okay, but that's not what I got in the queue. I got in the queue to say, Evan, I tried to make the good faith thing work with Evan, culminating in our 14th Amendment book, and I was not able to do it. It turns out good faith is not enough. The way I would summarize it is bad faith is sufficient, but not necessary. to find a law that exceeds the proper powers of government. Other things might also show that. However, I'm very interested in Judd's observation, which I'd like to know more about, that maybe the conception of good faith had more objective content than simply bad motives or something. And then maybe good faith could work if it was thickened up to that point, but I don't know that, just maybe. So I would just say that's not right. We tried it, didn't work. Now, the second thing I would just say is I would second Larry's point about your discussion of paternalism. You just have not presented any evidence in support of this. The evidence you've presented doesn't support your conclusion. I urge you to change your mind about this. Paternalism is not an appropriate methodology, appropriate consideration, not in a literal sense. He wants you to take out, what did you want to take out?
Ex parte Smith.
Yeah, I want you to take out Mugler. So what Mugler says, parts of it is, lists, when it determines manufacture, sale of intoxicating drinks for general and individual use as a beverage are or may become hurtful to society and constitute therefore a business which no one can lawfully engage. No one may rightfully do that which lawmaking power upon reasonable grounds declares to be prejudicial to the general welfare. And this is what all the sources are saying. Public morality is not necessarily the same, and this is Eric's paper, meet Eric's paper. Go look at Eric's paper for the evidence. Public morality is not the same thing as immorality behind closed doors that no one knows about and can't affect other people's behavior and can't corrupt them, all of which relates to public morality, and all the sources are about, they're either about public morality or they're about morality, and you're not clear whether they mean public morality or not, but by and large, I think the evidence supports this, and I would just, lastly, Harlan also in the same quote, unless it is apparent that its real object is not to protect the community or to promote the general welfare, that's not paternalism either. Now, and as for sources, I would ask you to take a look, and there's lots of sources on this, but the two that came to mind was John Compton's The Evangelical Origins of the Living Constitution, 2014, and Tom West's The Political Theory of the American Founding, 2017, both of which deal at length with alcohol prohibition, the prohibition of lotteries, and what was the political theory by which those things could be reached. And it was all a harm to others, harm to the community, against the general welfare rationales, not individual, paternalistic, do it for the benefit of the person themselves and only themselves. And so I would just urge you to retract that and replace it with something else.
Okay. Yeah, so this is not published, and I mean, frankly, I don't know if this is ever going to get published as a standalone. So I think I've tormented lots of you with my story of my magnum opus, the 800-year story from Magna Carta to present day of all the 14th Amendment principles. So it might just be a component of that. So I might Krotsky-like disappear for 15 years and then, emerge with something with some learned footnotes. But no, I really am I'm realizing that I'm reading a lot of, I'm clearly reading in a lot of my own sympathy for paternalism into the sources, and whether there really is nothing there, I'll give it some thought, and I'll certainly use this as an excuse to read a bunch more books instead of doing my administrative stuff.
Let me make one suggestion to you. Actually, there is an area of 19th century law that you probably will find paternalism in. It's family law.
Well, yeah, like parent.
Yeah, it's there.
Yeah, that's the thing that I always go to, like minors and minors, the ORS, clearly. But.
Relations between husbands and wives. It's paternalist.
Okay, so we don't want to be circular here, but I will look into.
They don't call it paternalism for nothing.
Yes. Paternalism and parentalism.
So anyway, so it's there. It's there. It's just that what Randy's talking about is sort of like legislation in the public arena, right? The regulation of business, the regulation of things. There you have the police power ideas. The police power ideas are not essentially paternalist. They are about public morality, right? It's what Eric was talking about.
Okay, so I'll trust Randy when he tells me that or Larry when they say I'm misreading a source, but when Jack's telling me that there's a consensus, really will.
Then I do have to talk about this. You cannot base a theory of the original meaning of the Equal Protection Clause, the Privilege and Immunities Clause, on 3 Republicans you like. There were lots and lots and lots of Republicans. There were lots of people who voted for the 14th Amendment in Congress. There were lots of people in the states who adopted them. The people that you like, and I like too, Carpenter and Chase, they were not the dominant strain of republicanism on a whole bunch of issues. They were correct, they were right, but they did not represent the standard view of most people who supported the amendment.
Well, this is it. Because our obligation is not to take the standard view of the facts circus 1868. It's to take the correct views of the fact. That's what the sense reference paper is about.
That is why I'm so glad that I got to comment on this paper, because we both agree about this. We both agree that original expected applications are not what the Constitution commands. The problem in this paper that I saw when I was reading it was that you slid into things like what was the status of law at the time? What was the original law at the time?
Why do I say that?
You're talking about civil rights.
Me with Will.
Where do the concept of civil rights come from? They're common law rights.
Citizens.
They're the rights. They're the common law rights.
It's the text.
You see, in other words, what you're saying, it's really Mike Rappapart's point. Are you really going to take most of the settled law and just simply throw it out the window?
No.
Is it your view?
I'm not just going to throw it out the window. Not just going to throw it out the window. Okay.
No,
so Mike
you'll slide it over the windowsill, and then you'll tip it over slowly.
I will pull off to the side of the road. I will think about it carefully. Okay. No, but Christina's absolutely right that
Jack, you're not helping.
Yeah.
You're not helping.
Jack,
you're not helping. You want to help? You're not helping.
You're trying to get me to entrench myself so that I say crazy stuff. But I'm really gonna spend some time thinking about this. So, mistakes were made. Nobody's interested in the 15th century stuff. Equality has a long history. So. Anybody read Henry VI Part 2? Okay, so this lady who's compassing
we speak of nothing else here.
Yeah, so women get due process rights in a statute in 1442. These treatises are presupposing women's equal right to well-being in the War of the Roses time. So there's a lot of good in the traditions too. Okay, tradition of women in commerce. My goodness, Proverbs 31. 3,000 years ago. So it's not like, we just had this idea, hey, maybe women can buy and sell stuff, own property. This is, it's recovering old traditions too. The daughters of Zelophehad have some inspirational value as well. I agree. Going through at least a few of these in really, in careful detail would be good. The book is ultimately, I'm going to be pretend I'm the 10th justice in all the 14th Amendment cases and give my little kibitzes about what I would have done in all the cases. So it's going to be, it's really going to be lit, the book. But it'll take a while. It'll take a while to read. So.
Can you finish the sentence that started with Christina's absolutely right?
What did mistakes were made. Mistakes were made. Yeah.
It's fine. You don't have to.
Yeah.
Do we have any merch that says that?
Mistakes were
Can
made.
we?
No, Christina's absolutely right. Just
yeah. Tacit quantifier.
We still have a couple more in the queue, so I think maybe we should move to the next.
Yeah. Okay.
So similar to others, I understood it to really just be focused on good faith and sort of subjective intentions of the legislators, and it seems like your answers are confirming that's what you think it is. And in the Bradwell case, I understood your answer to be saying Bradwell was wrong because they didn't truly look behind the real intent of them. And I guess similar to others, in the paper itself, I read your description of Bradwell. I thought you were saying it was wrong because they got the facts wrong about what women were capable of. So I think if in fact your argument is that it was wrong because they didn't dive into the real meaning for it, that should be made more clear. And then my other question is sort of thinking about this in dialogue with the other Eric Clays's paper on the police power. If there is also a more general notion that the police power only allowed regulations of citizens and limitations on their freedom, or regulations in general of the people for legitimate reasons, what additional work does this principle have for citizens? In other words, maybe you disagree, or maybe you're not convinced of others' arguments about the police power or what states can legitimately do. But if there's a broader rule that the police power only allows legitimate regulations or regulations in good faith, could it possibly be that this is redundant if yours only applies to citizens, but it doesn't give citizens any more protection from bad faith legislation than just the general populace has?
Okay, so the first thing is that after my dear friend Jack jawboned me that I should come to this conference for some amount of time, he then suggested that I really need to speak in this session. And after his having repeated that a few times, so here goes. So, so when I read your paper, I sort of decided to read thinking about what it would mean to extend your method from gender to race. So I, looking at the 14th Amendment, thought that we could say that the equal civil rights formula, the 1866 Act, is really rejecting the equal political rights claims, as you note, of black men and women. For example, the Seneca Falls, petition or declaration as demanding the right to vote, but you can take Victoria Woodhull or Frederick Douglass or the abolitionist conventions before the war, and they're speaking in the Equal Political Rights Register. So that framework is getting repudiated in the civil rights formulation. And I should also mention that Corfield speaks of the elective franchise as a privilege or immunity of citizenship, something that the women's movement continuously emphasized in its testimony before Congress and otherwise. But in any event, so then we look at 14.2, and 14.2 is essentially authorizing or allowing states to deny suffrage to black men. And there's consequences for it, but it's acknowledging that it can be done. And so I was thinking, okay, so we have a 14th Amendment that is allowing distinctions on the basis of race. That's why we have a 14th and a 15th Amendment, we know from the sequence of Reconstruction. So originalists should not be embracing a radical anti-classification principle, and about race. And then we think about our modern jurisprudence with the tiers of scrutiny, and well, we could just think about Justice Scalia, who, before he dissed the idea of there being any heightened scrutiny for women under Virginia, had already voted for strict scrutiny about affirmative action extending to whites in Croson. So there's Croson vote about strict scrutiny extending to racial classifications before he's suggesting that there's no coverage in Virginia. Or we can think about SSFA today, where originalists on the court don't join Justice Thomas, who's finally, after decades, at least put out what I think is an historically implausible originalist opinion for affirmative action. Now, I'm not going to go into the particulars. We could get deep into whether an anti-classification principle should or shouldn't apply to the case of affirmative action based on Friedman's Bureau or what I've said about Section 2 or otherwise. But I was just thinking about whether the tiers of scrutiny apply to race and thinking about what you're saying about gender. And when I've looked at what it is that originalists on the court have done on the race case, I've thought, and my own responses here, I think, well, I'd go for intermediate scrutiny just like they've gone for strict scrutiny in the race case, rather than embrace an originalist model, which they have not embraced in the race case. Why would I embrace this model, which I think, on your view of traditionalism, would go much more towards a tradition of coverture, as Jack was suggesting, than not? The talk about paternalism is really an integral part of the justification of virtual representation in householding and part of the coverture model. So to wind up here, my alternative, if we're going to embrace a form of originalism, would probably tend towards James Fox's counterpublics, where you embrace a much more expansive view of the public sphere that included, from today's vantage point, those who were denied the vote in the past, but who, by today's commitments, we would say should have been allowed to be enfranchised. on the basis of race or sex. So, but, we would extend today's notion of equal regard and include other persons in the public sphere who were then denied the right to vote, and then we might have a different view about what the 14th Amendment would mean, rather than talk about mistakes. But that's a perspective on dealing with these facts. But I note that I could just simply be selective in my view of interpreting the Constitution and take the path that, originalists on the courts have taken in the race case and not done originalism, and that might be the more sensible path rather than trying to persuade you all of this view of counterpublics. So that's a thought.
I want to just encourage you in the opposite direction. If the facts of originalism lead in a certain direction, the job of the scholar is to tell the truth and let those who have authority to make laws or not make them, or courts interpret them, they can do what they want with what academics discover. You may know that I think that race and sex are dramatically different under the amendment, in part in relation to what Jack was talking about, tradition and equality. Coverture was part of tradition, but caste, the common law knew no caste, as one court said in the 1850s. It has to be something added on to the deeper, broader Anglo-American tradition, like slavery. So recovering the tradition would, in fact, have an effect on racial classifications, but not on sex. About the facts that people knew in 1866 to 68, I think you understate the degree to which the people at that time are consciously aware of claims of justice against coverture and women's exclusion from the suffrage. Coverture is on the table. It's being challenged in state constitutional amendment conventions. Suffrage is on the table. The Kansas and Wisconsin legislatures ratified the 14th Amendment and said, let's grant the suffrage to women too. What's noteworthy is nobody at that time thought the 14th Amendment had anything to do with those changes. As to the suffrage, yes, but it wasn't. It was because of the privilege of immunity, and then coupled with the 15th Amendment, and then the Corfield argument that was mentioned. Lastly, Carpenter's argument is even more nuanced because he is also arguing in Slaughterhouse, and one of his arguments is it's outrageous to say how broad they think the economic liberty is, because that would exclude statutes like women's protective statutes that clearly are constitutional. So I think what's going on in Bradwell is misunderstood. Bradwell, by the Illinois Supreme Court, was expressly identified as capable of being a lawyer. So it's a question of wholesale exclusion of a citizen who is identified as capable of doing what the profession is.
Okay. So why embrace the model? Okay, so here's one thing I'm not doing. I am not looking at a whole bunch of male chauvinist stuff from 1866 and saying, that looks great to me. What I'm doing is I'm looking at this Constitution, and I'm trying to understand its nature, its hexaity, the thisness of the Constitution, and I'm looking at the oath that the justices have sworn and trying to understand what makes statements of the form the Constitution requires X true. What's the truth maker? So it's not just looking inside my bag of desires and looking what I want. Why embrace it? If you're a justice, you've already embraced the Constitution. You have to figure out what that is. So that's why I think I'm committed. I think the justices are committed. I don't want to say something that I don't want to be complicit in their violation of their oaths. The meaning is binding because that's what this Constitution refers to, and I've got obviously a bunch of articles about that. Crowson, here's a reason you might want to get rid of the tiers of scrutiny, okay? Because you don't get this Crowson, this automatic. So I talk about in the intermediate scrutiny, only 3-2 beer only for young women, and the draft only for young men. Well, in strict scrutiny, you've got the black code's not, limiting occupations for black men, and, universities trying to help out people who have been, mistreated. I mean, they're very heterogeneous, okay? So Justice Marshall's arguments against strict scrutiny, I think, have a lot of weight. Now, so he wanted to melt everything down. He's, Stevens, Berger, there's a bunch of people who want to get rid of the tiers of scrutiny. One reason to make this normatively attractive, again, the question is whether it's expressed in the text of the Constitution, but one reason that it might be normatively attractive, or like not so normatively unattractive, that you're willing to, misrepresent history to get a different result, okay? Is you get less scrutiny for affirmative action. So there, my book has the modified view of affirmative action and discrete and insular minorities, and no need to get into all that right now. Everybody thinks Corfield. I mean, a lot of people say Corfield, to which may be added the elective franchise. I don't think it's so obvious that Bushrod Washington thinks voting is a privilege of citizens of the United States. Benjamin Butler thinks it is in 1871. A lot of people read it that way, but I think it's a little bit ambiguous. James Fox's stuff, the way that language is being used outside the 39th Congress, absolutely. That's very important. And I think, broadly speaking, the Freedmen's Conventions confirm that the language is being used by people demanding rights in a very similar way to the 39th Congress. I don't think you can read Section 1 to include voting rights given the existence of Section 2, which explicitly countenances not just racial limits on voting rights, but all kinds of other ones. It has just a House penalty. That's how Bingham describes, he says Section 1 doesn't include voting rights because look at Section 2. In context, there's a broad reading of privileges of citizens that includes active citizenship, but there's a narrow one that's passive only. Tommy's point, one thing I did want to say, it's not just good faith. It is a duty of impartial attention to the interests of everybody. So if you're shutting your eyes, or even if you're just not paying attention to the fact that your policies produce great harm for people, that is also a violation. So if you're a principal, if you're an agent acting on behalf of a principal, you have a duty to be informed, okay? So the duty to be informed is very important. And I go into more detail in the citizenship and solicitude. I mean, it's an affirmative obligation of solicitude, contrary to Washington v. Davis.
I was going to add that there's a literature on fiduciary government that you might find useful. And it is not exactly the same as your notion of solicitude, but they're interesting because you're using the agency model.
Yeah, Lawson, Adelson, and that gang. That's
Yeah, so there's a lot of interesting stuff.
where I'm getting.
There's a lot of interesting stuff about fiduciary.
So you remember Tushnet, his famous Justice Kennedy. One of the things he thinks is super important to get. Now that we've got a Burgerfell, we can worry about Washington v. Davis. Okay, so if you don't like Washington v. Davis, this view has something for you too.
I wanted to talk about coverture because I do think that's the single example of having to do with an overt sex discrimination law that comes up in these discussions. First, I think we should not assume that all laws on the books at the time the 14th Amendment is passed were therefore consistent with the 14th Amendment, especially when they are under attack and eliminated fairly soon thereafter. What's interesting about the coverture example is that it's actually discussed on at least two occasions, maybe more, but at least two that I can think of during the deliberations over the 14th Amendment. So we actually know what they think. And the way the discussions went is that opponents of the amendment would ask proponents of the amendment, well, does this mean that coverture laws are unconstitutional? And the initial reaction of the defenders of the amendment was always to sort of deny, no, it doesn't mean that. And then they would ask why. And not once, Jack, did any of the supporters of the 14th Amendment appeal to any of the ideology that you were talking about and imputing to them. No doubt there was lots of sexist ideology in the middle of the 19th century, but there is no reason to impute that to the framers of the 14th Amendment. They do have an explanation for coverture laws. It is a purely formalistic explanation, and by the way, it is stupid, and you can tell from the debates themselves that they realize they just had been fucked. So basically, they say that it's okay because it's treating it's treating each of the classes of women equally. To which the response was, well, and they're just like Reva Siegel. Let's apply that logic to race, and it produces an intolerable result. And they simply cannot explain coverture. And they make no attempt to justify it in terms of public reasonableness. By the way, I do agree with Jack that the standard that they seem to be applying to these questions is not subjective good faith. It is some kind of public reasonableness. I think Chris's reformulation that I just heard 2 minutes ago might be the same as that, but the point is we cannot. I think it'd be a mistake, historical mistake, to impute to them that ideology, and to the extent that somebody is saying it's baked into the 14th Amendment, I just think that's just false as a historical matter. Now, there's been a lot of talk about Bradwell. As if Bradley's concurring opinion were the majority opinion in Bradwell. It is not. He is outvoted. The majority opinion in Bradwell is just like Minor versus Happersett. That is, it defines, what it says is that lawyers are officers of the court, and thus to serve as a lawyer is a political right and not a civil right. Now, one might agree or disagree with that, but it has nothing to do with any of the business that Bradley mentions. And so Bradley's a position, but what we know is that he's outvoted. He's in a minority, and we just should not treat the 14th Amendment as if the original meaning was what Bradley said about it in Bradwell.
My question, I think, is a version of Christina's question, so maybe I should say Christina's clearly right. But I'll press on and ask, why do you see the tiers of scrutiny as necessarily antagonistic to your view as opposed to complementary? In the sense that why can't tiers of scrutiny just be an implementation of equal solicitude, good faith, however you want to describe your test, but in some situations, we're particularly suspicious that there is, in fact, equal solicitude, good faith, et cetera, going forward because of the bad history in particularly, let's say, in race. So we take a really close look at these because we really doubt that good faith is going on here. And as to more general regulations like optical, generally we're willing to assume good faith, though we might, in extreme situations, you might find that it's not there, and that's your low scrutiny. And then your intermediate scrutiny just comes in on the theory that although there are some regulations are legitimately premised on differences between men and women, a lot of them aren't. And so you want to take maybe not as close a look as you do in race, but you do want to take a pretty close look at it. So this is just the theory of the tiers of scrutiny, and just why isn't that compatible with your test? It's just a question of what the burden of proof is in the implementation of your test. Why do you have to set yourself so strongly against the tiers of scrutiny?
So thank you for inspiring quite a discussion. So first comment, when you're discussing Steve Calabresi's paper, you should also discuss prominently Reva Siegel's paper, She the People, on the relationship between the 14th and 19th Amendment. You do cite it, but not, it is the leading paper on this topic, so I think Reva was too polite to say that. Second, when you're getting rid of the tiers of scrutiny, the question is the replacement better? It may be that terms like substantial and important are not 100% clear, but this discussion has suggested that neither are the terms good faith or genuine very clear, and so I think there's a question of whether the approach that you offer is really judicially manageable. And the final thing, to the extent you are focusing on what you call an empirical analysis, and people are debating whether it is in fact empirical, what do you make of the fact that there is a lot of skepticism on the current Supreme Court about empirics, right? Justice Thomas raised a lot of questions about that in Scrutiny, and the reliability of the empirics that one might get from academics, and who is going to trust whom when you're trying to do that analysis. Okay, so skeptical about empirics? I think you got to go with deference to the legislature. So, I'm not going to, if I'm worried about scientists, I can't just, defer to, 1976 guesses by the Supreme Court. So I don't think we have any alternative to that. Mike's point, it could be an implementation. Yeah, but it's not a good implementation because of the heterogeneity point and the three buckets and the cliff between bucket 1 and bucket 2. So yeah, you could say that, and that would be clarifying to like what this is, and this should be replaced if it's not a good implementation about when we should be skeptical about the facts. Judge. Yeah, so the fact that there's a law on the books in 1866, and actually, you know that some of them are going to be unconstitutional because it actually says no state shall make or enforce. So they've got existing laws that abridge the privileges or immunities of citizens of the United States. Don't just make any new ones, but don't enforce the ones you've already got. It was discussed, I think I don't know if, at least one of the discussions was in February 1866 with the Bingham Amendment, so there wasn't a real clear textual focus. I mean, the Bingham, the initial, the February 1866 one. The textual question wasn't as clearly framed, but you're exactly right. There wasn't a good answer. There wasn't a rationale, and it wasn't, the rationale is what's important, and the rationale tied to the text. Unfortunately, that discussion, the text wasn't what they initially adopted, and it was kind of confused.
Thanks, everyone.